Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today we're on the estate planning of the rich and famous topic, and today's episode is on the country music star Naomi Judd, who recently passed away the year this episode is being recorded in 2022. Specifically, she passed away on April 30th, 2022. Before we dive into what has happened estate-wise following her passing, let's talk a little bit about Naomi as a person first. According to her Wikipedia page, she was born in Ashland, Kentucky, a fellow Midwesterner. I love it. Naomi had her first child named Christina when Naomi was the age of 18. And fun fact, well, Christina is her also famous daughter, Wynonna Judd. Wynonna was just her stage name. 4 years later, she had another child, Ashley Judd, in 1968, who turned out to be the actress that we all know. The Judd name is sure known for their country music, right? In 1983, Naomi and Wynonna formed the Judds, which became quite the successful duo. In fact, they won several awards, including Grammys and CMA awards. Though in 1991, the duo stopped performing together, but not until they did a farewell tour together. They stopped performing because Naomi was diagnosed with hepatitis. Wynonna, however, continued to perform just as a solo artist. Later in the 1980s, Naomi met and actually ended up marrying a gentleman by the name of Larry Strickland. They got married in 1989. Larry, too, was in the music industry. He was a singer, musician, but also did some producing as well. They were married for 32 years at Naomi's passing. It was somewhat well known, at least to those close to her, that Naomi had been struggling with depression, anxiety, panic attacks, and suicidal thoughts. In fact, she was prescribed medications to help through her mental struggles. Tragically, Naomi passed away on April 30th, 2022, from a self-inflicted gunshot wound. She was 76 years old at the time. And perhaps equally as tragic, she, along with Wynonna, were set to be inducted into the Country Music Hall of Fame the very next day. So sad. So as we sit here today in September of 2022, Naomi passed away about 3.5 months ago. And I hinted at the end of my last episode, when I normally do a little sneak peek into what next week's topic is going to be about, I mentioned that even though Naomi had so recently passed away, that there's some things kind of already going on, and things hitting the news like Larry is the executor, and Wynonna and Ashley are excluded from the will. So many headlines. It has been confirmed that Naomi has a last will and testament, which was signed in November of 2017. So hey, at least she had something estate planning wise. And since wills go through probate and are public record, it's been uncovered that Larry Strickland, her husband, but not the biological father of Wynonna and Ashley, is the named executor in her will. As a blog by Farr Law Firm based in Virginia shares, Naomi named Larry as the executor. That's quite common, since Larry, after all, is her spouse. Though sometimes squabbles break out when the spouse is the executor, but the spouse who is the executor is not the biological parent of the person's children. And we all know families where squabbles like that would happen, right? I mean, I know I sure do. As the blog mentions, Larry is given an immense amount of discretion while serving in this role as executor. The will states that Larry has, quote, full authority and discretion to do what he sees fit with properties within the estate, including selling or leasing them, without approval of any court or the joinder of any beneficiary, end quote. Beyond that discretion, which is a lot of discretion in my professional opinion, Larry is also entitled to, quote, reasonable compensation for his services and any expenses, including attorney and accountant's fees, end quote. And that sure doesn't surprise me. In fact, that is very standard. Executors, at least here in Indiana, are always allowed to be compensated for their time and be reimbursed for expenses that they front on behalf of the estate, unless the governing instrument puts the kibosh on that. Interestingly, as the Farr Law Firm's blog explains, if Larry was unable to serve, then it was Naomi's brother-in-law, Reginald Strickland, and Daniel Waiter to serve as co-executors. Therefore, neither of her daughters were ever even in the running to be in charge of Naomi's estate. Interesting, right? So now let's shift to who is getting Naomi's estate, beneficiary-wise. According to most articles and sources for this episode, it is said that Naomi's estate is worth about $25 million. So when we're talking about who is getting what and how much, that's the dollar figure we're talking about. Naomi's will left her entire estate to Larry and nothing at all to Wynonna and Ashley. Again, I didn't really see too many articles talk about Wynonna and Ashley's relationship with their stepfather, Larry, but this reminds me so much of something I talk about in my own conference room often with blended families. When you have just a last will and testament, I often say it's like a race to see who dies second, because whoever is left standing can not only change their will, but it's now their will that is going to govern assets at their passing. So just because assets, came to Larry or will come to Larry from Naomi, upon Larry's death, those assets do not boomerang back to Naomi's will. They go through Larry's will. So if Larry is feeling awfully generous, he could leave assets to his stepdaughters, Wynonna and Ashley. Can he? Sure. Does he have to? Absolutely not. It is said that Larry does not have any biological children of his own. But the scary part about what I just talked about is, what if Larry meets someone and gets remarried? And what if those assets he received from Naomi's estate go to his next wife? Or heck, even a girlfriend? Now, maybe Naomi would have been okay with it. Maybe she would not have had a big deal, about that sort of thing. Some people don't care about those sort of things. But I think a whole heck of a lot of people would not be okay with their hard-earned assets going to their spouse's next significant other. The awesome thing is that it is possible. It is possible to eliminate all of these risks. And you can do so much through something called a trust that basically a will just flat can't offer. For example, through a trust, Naomi could have provided assets or income or both to Larry for his lifetime. And then at Larry's passing, Naomi could have designated what happens then, so perhaps to her daughters. Naomi could have also put restrictions in place on Larry, so if he did remarry, maybe instead of direct assets, he would have been entitled to income. And through a trust, we probably would not even know about who is where and who is getting what, because it would all be getting settled privately and outside of the probate court process. Beyond the saga related to executor and beneficiaries, there is even some stuff going on about the validity of Naomi's signature on her will. Now, a lot of the sources I used for this episode did not talk about this. So at this point, I'm not going to spend a lot of time talking about it because maybe it's not even a real thing. Though the Farr Law Firm mentioned in their blog, and they attributed the story to an article in OK Magazine, that a lady by the name of Peggy Walla, who is a handwriting expert and private investigator, states, quote, "The initials and signatures are traced. They are not written by her. That means someone put a lighter piece of paper over her regular signature and traced it," end quote. Well, that's a rather intense allegation, if I do say so myself, though it's not really gained too much traction, too much steam, so at least yet. So I only mention it on this episode as a heads up that there's some scuttlebutt about this going on. So if it does turn into breaking news, you'll be like, oh, that Jenny girl on Legal Tea talked about it. Or if nothing turns, if it turns into nothing, well, you'll probably forget I mentioned it anyway. Because Naomi has not been gone too long, this is all we really know so far estate-wise following her passing. Will there be more? Oh, I'm sure. Will either the girls contest anything? Will the handwriting thing become something? Will things just smooth over and time will pass and the estate will close? There sure is a lot in the air right now. And actually, I always try to do one last search before I decide to record an episode, just to make sure nothing earth-shattering happened between me writing the episode and recording. So I did that. I searched Naomi Judd estate right before I recorded this episode. And the first thing that popped up was an article on radaronline.com from less than a month ago, I think 2 or 3 weeks ago, that was titled, "Validity of Naomi Judd's Final Will Questioned. Battle for $25 million Estate Heats Up." So in that brief article, it actually does talk about, Naomi's signature in her will, Naomi's signature in her will. And they also even mentioned about supposedly Wynonna talking to lawyers about possibly contesting her mother's estate. I think I saw somewhere in my research that Ashley Judd was basically like, I don't care about the money. So I don't think she is really expected to kick up a fuss. But who also really knows? Only time will tell. As we begin to wrap this episode up, I'm conflicted. I'm conflicted on what my parting words for this episode should be. Why, you ask? Well, as you know, I'm always talking about people doing their estate plan on here. Heck, our hashtag around here is #DoYourEstatePlan. I'm conflicted because Naomi did her estate plan. She did a will, but to me, it was not enough. She could have done more planning and things probably would have been buttoned up better than they are right now. So I kind of feel like I'm now raining on the parade of someone actually doing their estate plan. But it comes from a good place, I promise. And maybe I should update our go-to theme around here on Legal Tea to doing a good and solid estate plan. I just truly feel that a will was not enough for Naomi. She could have accomplished so much more with more planning. And I suppose a will is better than nothing, but I would have encouraged her to do more. And maybe the attorney did, and she didn't bite at the opportunity. Okay, let's wrap this episode up. Next week, we are back to a cautionary tale episode where we talk about real-life clients and real-life cases that I or my office have worked on. During that episode, we're going to be talking about powers of attorney, which I know it doesn't sound like the most exhilarating topic in the world, but there is a trend that I am seeing with this document that I really want to talk about. The trend is that the document is usually titled something like General Durable Power of Attorney. But once you actually read into the document, which is usually just, 3 to 5 pages, it's not a general durable power of attorney. So we're going to dive into those words, general and durable, and bring up a couple new words, limited and springing. and why a true general durable power of attorney is likely the way to go. So we will dive into that next Tuesday, Legal Tea listeners. Until then, take care and be well.